Okay, welcome everyone. Today is Monday, June 30th, 2025.
It's colored.
And this is a special meeting of the City of Asbury Park Planning Board. Chairwoman Kurzak, can you please call this meeting to order?
This meeting is being held in compliance with the Open Public Meetings Act, Chapter 231, Public Law 1975. Adequate notice of this meeting has been provided to the Coaster and the Asbury Park Press by publication of the annual meeting notice and posted on the Municipal Bulletin Board and municipal website. All notices are on file with the Board Secretary. Official action may be taken on the following matters before the Board. This meeting is being recorded by APTV. Please join me to salute the flag. Pledge allegiance
To the flag of the United States of America, and to the republic which stands, one nation, under God, indivisible, with liberty and justice for all.
We'll now take roll call. James Bonanno.
Here.
Councilwoman Clayton.
Here.
Jim Henry.
Here.
Jeremy Hoffman is absent. Mayor Moore is absent. Jen Souter.
Here.
Daniel Shinameo is absent. Bob Zuckerman absent. Kathy McLaughlin. Here. Vice Chair Goonan.
Here.
And Chairwoman Barbara Kurzak.
here. All right, our first and only application is the Asbury Park Housing Element and Fair Share Plan. Fourth round.
If I may, Madam Secretary, you have the exhibits.
Absolutely.
First exhibit will be the proofs, which I reviewed. They're in good form. We'll make that C1 or City 1.
Okay.
Second is the plan itself. We'll make that City 2, if you don't mind. Evidence.
C2.
Okay, and if Beth wants us to put the synopsis or the shorter form, we'll put it as C.
I have no objection.
Okay. All right. So we'll make it C3.
Yeah, I think it should be in there.
Let's get you sworn in. Please raise your right hand. You solemnly swear to affirm the testimony is right. You've got the details from the truth, whole truth.
I do.
Please state your name for the record
It's Elizabeth or Beth McManus.
and your affiliation with the city.
I'm the redevelopment and affordable housing consultant to the City of Asbury Park. Thank you very much. So, folks, thank you very much for coming on this special council or planning board meeting. I really appreciate that. The purpose of tonight's meeting is to review the housing element and fair share plan. And at the end of my presentation, I'll ask the board to consider it for adoption. And adoption, of course, would incorporate the document, the housing element portion of it, into your master plan, making it part of your master plan elements like the land use element, circulation element, etc. The other thing that it will do, adoption will do, is enable the housing plan to be submitted to the Affordable Housing Dispute Resolution Program, or the program as it's being referred to, which is the new body of the judiciary that's been tasked with reviewing and approving housing elements, as opposed to COA, which has been officially disbanded, and as opposed to Superior Court that handled our third round judgment or propose. The other thing that I'll ask for this evening is not just adoption of the housing plan, but if the board does find in favor of the housing plan and adopts it, I'll also ask that you adopt the resolution, because that also needs to be submitted to the program. And the reason why the resolution is on the agenda for this evening is because as you'll see in the slides, but we have a deadline to submit documents by today, a deadline to adopt the documents by today, and then to submit them within 48 hours. So we can't do the typical resolution a month later or so. So with that, I thought I would give an overview of a little information about affordable housing here in New Jersey, why we're here, why we engage in this process, and then, of course, what's contained in the housing plan.
Can we just take just one moment and to kind of clarify why we're here on the 30th, looking for a resolution and trying to move it at this pace, as opposed to what we would normally do?
So it might normally be on perhaps your regularly scheduled planning board meetings. And folks, the reality is that my schedule just couldn't permit it. I just want to be honest about that. I don't typically do your planning board meetings, and so what what that means is I have regular conflicts those nights, but more importantly, the month has been, it has been very much a challenge for planners and attorneys and other folks that do this work. And so I think this was literally the only night in June that worked for my schedule and that the board was able to get a quorum, although I think admittedly it was mostly my schedule.
And also that we also have to make sure that you were able to present in front of the council as well.
Yes, yeah, as well as that, making sure that we had time to get this before council, since governing bodies are largely leading these efforts, although it's the planning board that's tasked with adopting the housing plan. So yeah, we needed to get before council first, give public and council members an opportunity to weigh in on what was anticipated to be included.
All right, so what date was it in front of council? Wasn't it like, just like?
Very early, I think it was early June, 11th.
First meeting in June.
About the 11th or something
Yeah,
like
okay.
that?
2 meetings ago.
Okay, so 2 meetings ago, and at that point, from what I understand, the public was also
Yeah.
able to question.
Correct.
And so it was
yes.
presented in front of the council and the public at that time.
Yeah.
Okay.
In fact, the presentation that the members of the public and the council saw is virtually the same as what's going to be presented this evening. It's just been updated for the date and the change in audience.
And one other thing that I'd just like to mention, just for the record, is that we also included in the information that we provided to the planning board members, we also included the APTV recorded version of that presentation.
Oh.
So that our members could both see this earlier, which is sometimes a lot earlier than they would normally see things. And they also were given that link to be able to see that ahead of time if they chose to do so. So that we try to, understanding what the situation is, we try to give our members as much information as early as we possibly could to help mitigate some of this.
That's great.
Okay.
For those of you that watch the recording, I'm sorry, because you're going to hear a lot of repeated language, but hopefully that means it'll just be a little easier for folks to get through and understand what we're doing. So are there any more comments or questions before I get going? No? Okay. Okay, so just generally, why we're engaged in this process in New Jersey, there are really, I would say, 2 primary reasons. The first one is legal, the other one is just simply good planning. So from a legal perspective, for about 50 years now, we've known that, well, we've been directed pursuant to a New Jersey Supreme Court decision, the Mount Laurel 1 decision, that municipalities have a constitutional obligation to plan for low and moderate income households. And that court decision was quite long, and there was the Mount Laurel 2, 3, 4, several other cases that are relevant to what we're doing today, plus multiple versions of affordable housing rules. But at its very core, in 1975, the New Jersey Supreme Court said, towns, you must plan for households of all incomes, and essentially, as a result of that, really a variety of housing types. And in addition to simply directing that type of thought and planning into municipal planning and zoning practices, one of the follow-ups from later case law was this builder's remedy litigation. And that's a form of exclusionary zoning litigation, and it's something that just about every single municipality in the state seeks to avoid. It is a type of litigation that arises from typically, but not always, from a developer stating that the municipality hasn't met its affordable housing obligation, meaning it hasn't submitted an adopted housing plan, or it hasn't done what that housing plan indicated that the town would do. And as a result, the town is non-compliant. The remedy, the builder's remedy that they propose to the court, assuming they are successful in that assertion of the town status, is that they will assist in providing affordable housing. And that comes in the form of inclusionary development. And it is always something that is larger, more dense, and or taller than what the municipality would have otherwise permitted. If you think about the effort a developer would have to go through to receive a builder's remedy, it makes sense, I think in my mind, that they're only going to go through that effort if the zoning doesn't permit what they're proposing. So it could be a commercial district, it could be a single family residential district, it could be simply a district that doesn't allow the height and density that they're seeking. And when they are successful, it is hugely disruptive to municipalities. It means that your zoning and your master planning for that particular property is essentially irrelevant. Since the developer has, in that example, rightly identified that the municipality is not meeting its constitutional obligation, and they are there to help and assist. And so what I recommend for Asbury Park, like every other town in the state, that we do everything we can to avoid builder's remedy, because we simply want to control our own zoning and our own planning. The other reason why municipalities should go through this process, in addition to the very good legal reasons, is quite frankly, doing so promotes housing quality, it promotes housing affordability, and it promotes housing, or rather just general quality of life for those folks that are perhaps struggling to find housing that's affordable to them. So it's really critical in maintaining our planning and zoning framework, but also critical from the perspective of advancing quality of life here in the city and New Jersey as a whole. A little bit more about affordable housing in general. One of the questions I often get asked is, who qualifies for affordable housing? What are the appropriate incomes for obtaining low or moderate income housing? And this is a table that is replicated from your housing plan, but just as an example, if we look at a 3-person family, it could be 2 parents and a child, or 2 children and 1 parent, the maximum income is about $97,000 a year. So the incomes for low and moderate income households are higher than what I think a lot of folks expect, especially as we look at the moderate income range. And so this table identifies the very low, and moderate income ranges, all of which are varying types of affordable housing. And you won't see your housing plan give a lot of information about these 3 different income levels, but they are all incorporated into your affordable housing regulating ordinance. And anytime a developer is proposing to do affordable housing, just about any time, they're going to include a mix of very low, and moderate income households at the prescribed minimum percentages set forth in your ordinance as well as in other state regulations. And so just to follow up with that, some example rents. For let's say a 2-bedroom home, it's going to range between $600 to about $1,600 for an affordable unit, depending on whether we're talking about very low, or moderate income. Now, we have a variety of affordable housing minimums and limitations, and some of these are more relevant to the city than others, but I wanted to share it because I think it gives good information as to how the state thinks about affordable housing and what type of affordable housing is deemed most important. So on the left, we have citywide regulations or citywide requirements. And as I'll explain in a moment, this city doesn't have what's referred to as a new construction obligation. So I don't have a lot of concern about how the city might be promoting senior housing, et cetera. But I think this is still relevant to see, because you can get a sense as to the priority, which is family housing, which is simply just housing that is not reserved for, let's say, seniors or those with special needs, for any particular population. That has a 50% requirement, and that's actually applicable to not just your total obligation, but also the rental obligation. And you can get a sense as to the limitation on the maximum number of senior units that have been deprioritized in throughout our affordable housing regulations down such that it's only 30% that can be used to fulfill the obligation. And then a new-ish priority for very low-income housing has become important over the last decade or so. Those requirements that are applicable to your affordable housing developments are listed on the right, and these are the development requirements, where it includes the mix of 1 to 3-bedroom units and also the minimum requirement of 50% low income, as well as 13% very low income, which is a subset of low income housing units. So in order to participate in this process, to be protected from builder's remedy litigation, there are principally 2 things that need to be done, and one of them has already been completed. The first one was to participate in the process, and to do that through a governing body resolution adopted before the end of January that, 1, committed participation in the process, and 2, identified our affordable housing obligation that was adopted by City Council in January, submitted to the program, and so that first step is completed. The second step is to do exactly what we're here addressing this evening, which is to adopt a housing plan and submit that to the program. And as I said at the outset, the deadline for doing so is actually today. So let's get into our housing obligation. So we have, most towns in New Jersey have 2 types of affordable housing obligation. The city also has 2 types of obligations, but one of them is rather unusual. So the first one that's shared by all municipalities, that's the rehabilitation obligation. And that obligation has been originally calculated by DCA and assigned to the city by Superior Court via an order earlier in the year. That obligation is 214 units, and it's an estimate of the number of substandard units that exist in the city that are occupied by low and moderate income households. And it's simply based on census and American Community Survey data that's been extrapolated to provide that calculation. The second component of the obligation that most municipalities in Jersey have is called a new construction obligation, sometimes called the rounds obligation, like the 4th round, 3rd round obligation, etc. But Asbury Park is a qualified urban aid municipality, so that means we don't have that obligation. Never have, and don't through this 4th round. The other component that the city does have that this housing plan addresses is unusual and very specific to the city. It's not an obligation like you would find in the Fair Housing Act, but it's something that we need to respond to in our housing plan, and that is the number of outstanding RCA units. The city had ongoing RCA programs. We had taken money from a variety of municipalities in years past, and a portion of those RCA units have not been completed or were not properly regulated, and so as a result, we have an outstanding obligation of 206. And for those of you that have been listening to me talk about affordable housing for the last several years, this should sound familiar, and is what you're going to see. Our proposal to address your RCA obligation and your rehabilitation obligation is exactly the same as it was in your 3rd round housing plan. It's just simply been continued and brought forward to this new 4th round. So starting with the rehabilitation.
Can I ask a question about that? Just
Sure.
I'm trying to get it right in my head. We just completed the 3rd round process like 2 years ago, right?
Yeah.
Because there was a delay. And so now this 4th round, we're like right on top of it, doing it.
Yes.
That's why they're so close together?
Yes,
Okay.
yeah. So, yes, there was a delay in getting going in the 3rd round, simply because the city was an urban aid municipality, but we decided to participate. And then once we started participating in the 3rd round, it takes a couple of years to get through the process. And that's why our housing plans are only a couple of years apart.
Thank you.
Yeah. So our rehabilitation obligation, like I said, it's 214 units. The city is going to simply continue its existing rehabilitation program. And this is a program that will be available to low and moderate income homeowners, as well as landlords with low and moderate income tenants. And so what's required is that the unit be occupied by low and moderate income households, and that the unit need a major system improvement. So this is not for cosmetic changes, it's not for perhaps new paint on the home, but it's for major systems such as roofing, could be lead paint removal also, could be HVAC, for example. The program will continue to be operated by our Affordable Housing Administrative Agent, which is CGP&H, Community Grants Housing and Planning. They're a great organization that runs these types of programs all over the state. And what this more specifically means as them operating it, it means that folks that want to participate in the program will actually apply through CGP&H. We'll work with that organization to identify the work that will be completed, to construct the work, go through the entire program to confirm that the improvements were done properly, etc. Although I will say the city will be authorizing payment to the individual for the individual rehabilitations, but otherwise it is operated by the administrative agent. Each of these rehabilitations comes with 10-year affordability controls. So for the next 10 years, if it's a rental unit, for example, if those tenants leave, the next set of tenants or tenant will have to be income qualified, and as a for sale unit, the owner would have to resell the home to another income qualified household. So it will not only improve housing conditions in the city, but it will also create some affordable housing stock for a decade each.
Do you know
unit.
about how many of these we've been doing a year?
I think it is significantly less than 20 units a year.
Well, that's not
Yeah.
terrible. If we have 200, then 20 a year would get us there in 10 years. Okay.
I will, and actually on that note, there's no penalty, as long as the city creates the program, as long as we make it available and advertise it, there's no penalty if we don't have 214 households that participate. So that's okay. Our obligation is to make the program available to this number of households, but not to require that we have 214 folks that apply to the program successfully. So for our second component of what we're obligated to do, and that is to address the 206 RCA units. And so this project, the home plate site, is exactly as was set forth in your 2023 housing plan, which was exactly as set forth in the city's memorandum of understanding with the City Housing Authority and our settlement agreement with Fair Share Housing Center. This project and the negotiation regarding the rehabilitation program took place in the very early 2020s as part of our settlement agreement. And as part of that, we agreed to work with the Housing Authority to essentially create enough affordable housing units such that it was deemed to have addressed the outstanding RCA problem, or RCA units. The Housing Authority has been working with the city, working on concept plans, and so this project is moving forward. It just simply wasn't possible to get it done in the first 2 years after our housing plan, and so our third round housing plan, and so we're going to continue to move this project forward throughout the fourth round. But what it ultimately means is that we're going to be creating not less than 132 affordable housing units on, it's referred to as the home plate site, but in reality it is the home plate site plus the existing Lincoln Village development that you can see highlighted on the screen as well as in the housing plan. And so the home plate site is the undeveloped lawn area shown there that is shaped like a home plate. Lincoln Village is obviously the buildings immediately to the north. The project is located at the corner of Memorial Drive and Springwood Avenue, as well as Prospect Avenue. And it also has some frontage along Langford Street as well as Cookman. So essentially, it is most of a city block. As I said, 132 units will be developed between the two properties of Home Plate and Lincoln Village, with not less than 69 on the Home Plate site. And the purpose of those units will be to provide housing for the existing residents of Lincoln Village such that they have an opportunity to stay within the city, because the second phase is to demolish Lincoln Village and to construct additional housing on that property, to construct essentially the rest of the project, the rest of the 132 units on that site. And so our memorandum of understanding and our settlement agreement sets forth the terms for this process with, I think, some of the more important terms about guaranteeing the right to remain in Asbury Park for the existing residents, and also for alerting and advertising this housing to folks that may have been harmed by the poorly managed or incomplete RCA program, such that we're trying to essentially rectify some of the problems that came to be throughout the life of that program. The affordable units on both properties will have affordability controls of not less than 30 years. I also anticipate that the developer of the project, who will, seems unlikely to be the Housing Authority, they will partner with the developer of the affordable units, but those folks will go out for outside sources of funding, potentially including the low-income housing tax credit program. And additionally, the city will convey funding for the project as well. This is essentially funding that was unused or otherwise intended to be allocated towards the RCA program. That RCA program has been closed, and as a result, the money will be allocated towards the construction of these affordable units. And so with that, that is an overview of the housing plan. It is essentially continue the existing rehabilitation program to fulfill the rehabilitation obligation and continue our work with the Housing Authority to redevelop the Home Plate and Lincoln Village properties. And so the next steps are for the board to consider adopting the housing plan. If yes, I would also ask you to execute the resolution. We'll submit those documents to court. I'll work with your affordable housing attorneys to do so. Those documents will be submitted potentially tonight, if not probably before I wake up tomorrow morning. And then we will submit, there are supplemental documents that also need to be submitted to the court as well. In most of them, I think all of them are in draft form, and I'll work with counsel and your affordable housing attorney to submit those to the program as well. And after that, we simply wait for the compliance certification. Now, the compliance certification is the new term for the stamp of approval, essentially. Previously, it was referred to as the judgment of repose or substantive certification when we had COA, but the compliance certification is the new name set forth in the Fair Housing Act that will be issued essentially by the program. Now, I will say we have a 2-month objection period coming up, so we may get objections from folks, but we have through the end of the year to rectify those objections. If we need to amend the housing plan, we'll certainly do so. But if we don't get any objections, I would like to think we'll have a compliance certification before the end of the year. And so with that, folks, I'm happy to answer any questions.
Any planning board members have any questions?
I have a few. So some of these are just because I don't understand some things. So there, in the actual draft that you sent us of the housing plan, there are a couple of references to like complying with COA rules and COA regulations. But then I remember reading somewhere else that COA was abolished. So can you just explain to us how that works?
Yeah, it's a little bizarre. So COLA is abolished, basically. It is officially removed from the state via the 2024 Fair Housing Act. But notwithstanding that, the Fair Housing Act also says that municipalities shall craft their housing plan, calculate their affordable housing obligation consistent with the Fair Housing Act. However, municipalities have the right to rely on the adopted state rules for crediting and adjustments. And adjustments are not really relevant to Asbury Park, but to crediting. So it's this admittedly somewhat unusual circumstance where the state agency has been abolished, but we're still directed to use their first, second, and different versions of their third round rules.
Got it. One other question I had. So you had talked about the rehabilitation obligation. There's really no time requirement. Mm-hmm. The RCA obligation, is there a time requirement on that one?
Yeah, so the way that the requirements, it's an unusual circumstance here because it's not a typical municipally sponsored construction project where we are doing 100% affordable housing in order to meet our new construction obligation. This is a little bit different as we partner with the Housing Authority. The conventional type of project, which would be a typical 100% affordable housing project, would be 2 years to break ground from when your housing plan is adopted. Now, we're beyond 2 years from our third round plan. So my expectation is that we're going to get an updated construction schedule from the Housing Authority. And as part of our fourth round compliance, we'll be tasked with working with the Housing Authority to do what we can to facilitate their construction of the project. So I suppose I could say it's a two-year window to break ground, but we're in such an unusual circumstance where we're partnering with the Housing Authority as opposed to simply constructing our affordable housing obligation, such that I would expect that there may be justification for flexibility if the Housing Authority is unable to move forward. What we can do is make sure that the city is doing what is necessary to facilitate the Housing Authority to assign a developer, apply for construction funding, relocate residents to Lincoln Village. But I'm wary to say that that deadline applies to us in the same way it would apply to other municipalities, because this is such an unusual project that I don't know that there's any comparison in the state. So I'm sorry, I know that that's not a very specific answer, but that's what I can offer you.
The reason I ask is, I mean, obviously we want the project to move forward, but what I was also just thinking, like from a builder's remedy standpoint, could we ever get to a point in like 2028 where a builder says, well, you haven't done this?
Well, I would say that would be the case only if, I would like to think that would be the case only if it can be demonstrated that the city's not doing what we're supposed to facilitate the housing authority, or the housing authority is not doing what it has committed to in order to do the project.
And I have one last question, sorry. So on page 20, it's talking about the low and moderate split for units. And one thing I didn't understand is it says at least 13% of the units must be reserved for very low income households. Makes sense. But then it says additionally, at least 25% of the affordable units in each bedroom distribution should be reserved for very low income households. So it's like in one place it says 13% of all units, but then it says at least 20% in each bedroom distribution. It just seems to be and it might be a subset thing that I'm missing, or it might be just a typo. So I was just hoping we could take a look at that before we
I will. I'm sorry, I just wanted to stop sharing so I can pull this
sure.
up.
It was on page 20 of the draft, yeah,
Yeah.
where it says low and moderate income split.
One sec.
Just wanted to make sure we're saying what we want to say.
Yeah, let's see. Let's see, this is part of a new standard. Let me just confirm it. Sorry, folks, in 1 second. One of the issues that we're all struggling with in the state is we have new uniform housing affordability control rules that have been released by the state that are not yet adopted, but are nonetheless required to be implemented into our housing plans, and it just causes a little bit of a confusion. There's some conflicts in there. Let's see. I think I'm going to find that should actually be 13%, as opposed to 25%.
Yeah, I was thinking it might be 25% of the 50% of low count, but instead of the text just doesn't make sense. So I just want to make sure we get it right.
What I would recommend is that if the board's comfortable with it, that you give me the flexibility to adjust that in the final version if necessary. Yeah.
Sorry, that was everything for me.
Okay.
Thank you.
Thank you.
Any other planning board members have any questions? Okay. Since there are no members of the public, we have no questions from the public. Can I get a motion to open public comment?
So moved. Second.
Since there's no public, can I motion to close public comment?
Second.
Okay. Do any of the planning board members have any comments that they would like to discuss or present?
I just want to say I appreciate Barbara's questions and your answers, Beth, about the timing, because I did have concerns as to, I understand that all the things that you said, and it makes sense. I was just worried about being able to have everybody share any comments and get any changes made if necessary.
Yeah, it's a fair comment. Yeah.
But it makes sense. I know the whole state has been hectic about it.
Okay. Can I get tell me if I'm saying it right, Jack?
Motion to adopt.
Motion, I'll just say that.
Motion to adopt.
Okay, get a motion to adopt this, to the housing plan
Housing plan as presented.
as presented.
And can we just say
And
with the
there's-
condition that if Beth needs to adjust that one number, it's okay?
Right.
Okay.
Okay.
You have a motion?
I'll motion.
Second?
I'll second it.
I did not catch who second, sorry.
To the Jim or
Jim.
James Bonanno,
Yes.
Councilwoman Clayton,
Yes.
Jim Henry,
Yes.
Jen Souter,
Yes.
Kathy McLaughlin,
Yes.
Vice Chair Gunnan,
Yes.
and Chairwoman Kurzak.
Yes.
Now, has
Thank
everyone
you.
had a chance to look at the resolution?
Yes.
No.
Okay.
Should I print some extra copies?
We have a
Do you have a
copy.
copy?
I have a copy,
Yeah,
yes.
let's let Kathy take a quick
I can
scan.
print
Very
extra.
short.
Just in case.
It's actually prepared by council, Affordable Housing Council. I looked it over. Added one or two minor comments. Basically, it's just an adoption of the resolution. Sorry, I don't know why you didn't get it out.
We have been having very bad email issues.
Oh, okay. So I tried to send it to everyone.
It's been a problem. We're trying to fix it.
This is the key. Oh, okay, great. I can read all the whereases.
I'm sorry you didn't get a copy.
There's been a problem. Does anybody else want to take a quick look at it before we vote on it?
Can I take a quick look? Thank you. Sorry, I know I.
All right. Any questions or concerns about the resolution? All right. Can I get a motion to adopt the resolution?
Motion to adopt the resolution.
Second?
Okay. James Bonanno,
Yes.
Councilwoman Clayton,
Yes.
Jim Henry.
I'm going to abstain. Excuse me, I'm abstaining.
Jim Henry is abstaining, okay. Jen Souter,
Yes.
Kathy McLaughlin,
Yes.
Vice Chair Gunnan,
Yes.
Chairwoman Kurzak.
Yes.
So that's
Resolution adopted.
resolution adopted, and
I just need to sign.
we need to sign.
Okay.
We're done.
All right.
Thank you, folks.
All right.
Thank you.
Thank you for the hard work. I know it's been rough. Maybe you get a few days to relax a
Tomorrow night-
little.
Tomorrow's my first night off that I don't have something scheduled in like 2 months. I'm so pleased.
All right, can I get a motion to adjourn?
So moved.
Second.
Second by Yvonne Clayton. All in favor, none
Aye.
opposed?
Aye.
Aye.
Thank you very much.
All right, thank you.
Okay.